We're back from the short recess. Thank you for your patience on this. We just had to refigure the YouTube video. At this time, Senator Gumatauto, if you may continue.
Yeah, let me go ahead and ask it again since we're into the second part of this video. But let me go ahead and ask it. It was mentioned this particular bill is not new. So it was reported through the same committee report that was mentioned earlier from the 36th Guam legislature that there was an average of 7 cases annually involving medical malpractice in Guam. At the time, Attorney Robert Keogh, who was also asked to testify here today, he informed the committee that for his office alone, they handled 23 medical malpractice cases. Do we know if that figure is accurate, near accurate, and recognizing that these were cases, meaning the claimants had the money to each proceed with an arbitration case, what information, generally speaking, do we know about any of these outcomes of these 23 medical malpractice cases, specifically if the claims were settled outside of court or that any of the providers were sanctioned by their respective medical boards?
Okay, yeah, I think I understand your question, but I don't know if I have the knowledge to answer it. I don't know the details of the malpractice claim history for the island and the frequency of those cases, yeah.
Not a worries, and I'm hoping that with your assistance of the board that you can get that information back to the committee to be added to this particular committee report for this bill, if it's possible.
Yeah, I mean, you know, of course, the Guam board, our function is handling of complaints that come to the board, which can be separate and different sometimes than the
no, I'm well aware. So I'm hoping that when you go back to your next meeting, that you'll be able at least to provide that support. Speaking of which, and maybe they can help if you can't answer today, but for the record, how many medical practice-like complaints have been filed with the Guam Board of Medical Examiners against providers within the last 3 years, and what information can be shared confirming the veracity of these allegations and whether any action was taken by the board against any of these providers?
Well, I don't have all of that information here right now, so we could get that for you, but I don't have that information.
Yeah, I think it's important, for this bill, that number is added to this report. And why I say that, I believe, quite frankly, that the data and the information can bring a lot more context to this particular argument that we're having today, or I should say, discussion of policy. And I think that the data absolutely will be very important, if I could. And then while I'm sticking with you, I mean, if Dr. Berg was here, we'd probably have to pepper him, but you're here, so it's fine. But going back to the discussion earlier about malpractice insurance, and I know there was a mention about cost, but when we think about malpractice insurance, what information is available regarding any existing policy of the Guam Board of Medical Examiners and other healthcare-centered government boards requiring providers to obtain malpractice insurance, and recognizing that such coverage will be critical in the event that a claim is successfully made, and what options, if any, are available to an uninsured provider who actively treats patients?
Okay, well, I think that's a good point. So if I understand what you're asking, so I think, you know, in most jurisdictions, particularly in hospital settings, it would be expected that physicians and medical staff members have insurance. So that would be also something that is typically required when you apply for credentialing in a hospital setting with the federal system such as Medicare. So those things become much more complex if the insurance is not available. And as you point out, you know, one of the concerns I think that underlies that is that there needs to be you know, something that's sustainable from a financial perspective in the event that there is a big claim. We need to make sure that that actually can be supported, that the cost of paying that claim can be supported. So without insurance, that actually can, you know, in a way put the claimant at some risk that they don't actually get compensated appropriately. So that is also a concern in the absence of insurance. All
right, thank you, Doc, so much for that. And Madam Chair, I just made one more comment. And I'm disappointed that he left, that Dr. Joseph had to leave, but I just wanted to note for the record, I don't think I was part of this body when whatever he was mentioning, but I appreciate perhaps maybe his dissent, maybe his characterizations of certain things and actions, because I mean, quite frankly, that's what we're here for. But I don't recall being a part of the talk at the time. But just so people understand, Madam Chair, I think that's one of the beauties of these processes. We're allowed to come into a place where we might not always agree. And I mean, you let them go for quite a bit, but that's fine. But I want to just tell him that I was doing something else and I was not here. So I appreciate his input.
Thank you, Senator Gumatauta. Yes, and those people that he was against this bill were still sitting here as well. So I think the mass public is have been listening to this for years, many years, and they feel that something needs to change. You know, we're seeing more deaths that could be avoided, and that's why we're here, just to give the opportunity for everybody to state their opinions and respect their opinions too at the same time. So, other than that, Senator Sabrina Salas, do you have anything?
I don't have any questions. I did want to say thank you to everybody that came here to testify today. And I do plan on working with the doctors. I know this is a bill that was, from what I heard earlier, was kind of a carbon copy of a bill that was introduced previously, Bill 112, several years ago. So yeah, I'd like to go back and look at the committee report and see what amendments were recommended, what kind of testimony was provided then, and compare it to what was, presented today. Because 3 years, 4 years, 6 years is a long time for nothing to have been done when this was discussed previously. So thank you.
You're welcome, Senator. And for those who are listening, the bill was first introduced in the 35th Guam legislature as Bill 430-35. And again, in the 36th Guam legislature, it was introduced as Bill 112-36. And then the bill was amended to what it is, what you're seeing today, with some inclusions by Senator Parkinson taking the bill and adding his 2 cents to it. So that is pretty much the history for those who are listening. So this bill has been discussed for almost 4 years. And I would like to recognize Senator Parkinson. Do you have any questions you would like to ask, or do we move on?
No, I think we can just go move on.
Okay, Senator Terlahi, we have 2 more just to testify.
Yes, I guess I'd like to ask Dr. Willard. Earlier, someone testified that the Guam Board of Medical Examiners in the last 3 years, I think, they used the same amount of years that you did. While they have adjudicated their cases, they have not had any sanctions against any doctors. Is that correct? Do you know of any?
I've been on the board, I think, less than 2 years, and so I'm not sure about the history beyond that. I'm not aware of any types of specific actions taken in that time frame.
All right, thank you. And you said that the trial are going through a pre-screening would be slower and less effective to pay out patients. You think a pre-screening is slower than arbitration?
No, I guess I should clarify. What I mean is that I think the court system as a whole is more costly and slower, and I think the end result is that less compensation goes to the patients and families. So the pre-screening process, which was asked about before, I think it's really a comment about the court system in general, and the pre-screening process, I think, as it is outlined in the proposed bill, I think the main effect would still be to increase cases handled in the court system.
I can't tell whether well, definitely, because we're putting the pre-screening instead of at an arbitration panel, we're putting it right there at the court system, done by a judge. And it's actually, so you would not have to pay arbitrators, right? We'd have a qualified judge able to screen, and you would be still having your attorneys, plaintiffs and defendants would still have their professional witnesses who they hire. And so there are still costs, but replacing an arbitration panel with a judge to pre-screen. Pre-screening is done in many jurisdictions, and then they go straight to trial. And that I would think because you're not paying the judge. We, the taxpayers, are paying the judge. It's going to save you paying the panel of arbitrators, so that reduces cost. And because there are timelines involved, both the plaintiffs and the defendants are going to get swift determination of whether someone sees merit to this or not, and then whether it goes forward or not, that's going to be up to the parties. But I thought it was very, it's bad news that insurance costs are going up for providers, despite, even without the bill's passage, insurance providers are raising costs, just like they are for many other professions on Guam, increasing costs for insurance, and many other, even home insurance, everything. So I agree that that's a concern. However, providers that are raising their costs even without passage of this bill, I think that's just evidence that that's not the bill that's raising the cost. And I don't care what they tell you, because if they told me they're raising your cost because there's a bill that they might pass, I think I would challenge that or report them to some insurance commissioner. And speaking of the insurance commissioner on Guam is supposed to report to the Guam Board of Medical Examiners all malpractice insurance, whether doctors are insured or not. But there have been no reports. Since I was a chair of the committee, we followed up. We've asked the board to demand that report but none. So as far as I know, we can't determine who's insured or not, or how they're insured. And but I am equally concerned that insurance costs are going up. And I believe that might be the case nationwide, and it's not just a Guam thing, and it's not, and in fact, if our laws are the most protective of doctors across the nation, and they're still raising the costs right now, and I just think that's a big concern. But that's a concern that, I don't think the plaintiffs or the people who believe that they have been harmed, even in gross negligent cases, should have to bear. That's the thing. We're talking about a process that serves gross negligence, as Dr. Wen pointed out. There are cases of gross negligence in the same way as all the other cases that you think should be protected. But thank you, Madam Chair.
You're welcome, Senator Terlahi. Dr. Willard, you're excused now at this time, and you're also excused. I appreciate you taking the time to be here. And if you can, please submit in written format to my office your testimonies, if we don't have them already. Greatly appreciated. Okay. And at this time, I would like to recognize, Dr. Loom, she was here earlier. I'm recognizing her. I don't know where she went. So next is, Robert is yielding to the beauty in the house, the rose. So Maria Espinosa, you are now recognized.
Yes, thank you very much. And I believe it's officially afternoon.
Okay.
I support the intent of Bill 82-38. And I will read, and I hope you will allow me to interject maybe a couple more sentences as I read along. Dear Senator Taitague, I support 8238 as the findings and intent say the Medical Malpractice Mandatory Arbitration Act raises the cost of medical malpractice claims to prohibitive amounts. Such financial barriers can prevent those who have suffered medical malpractice injuries from seeking justice and reparations, close quote. This bill changes the process from the existing Medical Malpractice Mandatory Arbitration Act to the Mandatory Medical Malpractice Pre-Screening Process. And I will use the PS so I don't have to spell it all out. For those of you who don't know my story, I will summarize very briefly. My son Matthew suffered a cardiac arrest. We're not talking about a run-of-the-mill kind of injury, suffered a cardiac arrest shortly after he was under general anesthesia for a comprehensive dental procedure. He was resuscitated at this clinic, the Seventh-day Adventist, and transferred to GMH, where he lay for about 4 months before being discharged. He was bedridden. He had a feeding tube, a catheter, and a tracheostomy. Before his discharge, I thought I was sufficiently trained how to take care of his needs. I thought I knew what to do. Sadly, I discovered on his first night home that I was not sufficiently trained, and I was immediately overwhelmed with the responsibility of keeping him alive 24/7. I lovingly took care of my son for not 8 days, 8 years before he passed away on June 9th. And he did not pass away from COVID. It took me a few months to reach out to a short list of lawyers recommended to me. A couple of lawyers said they don't accept these kinds of cases. A couple completely ignored my calls. And since my son Matthew was a person with developmental disabilities who passed away on June 9th, I called the Protection and Advocacy Office in Agana. They declined because medical malpractice was not part of the services that they provided. Only one lawyer, and I'm sorry, I don't remember his name, took the time to explain to me that arbitration was mandated, that there is a $50,000 advance fee, and that if I lost, I could continue to trial, and that meant more money up front. He also said that even if I won the case, there would be so little money left to use towards home care, which was my motivation to go to trial. I already felt defeated. I just want to briefly mention the reason why I wanted to go and sue, because it was 24 hours. When you have a person at home with a tracheostomy, you don't know when they need suctioning. It is not trivial. You could be cooking and be right there next to his bed. You've got to stop when you, or you will kill him accidentally, because he's gonna choke on his own sputum. So it was literally a 24/7 kind of job. And all I wanted was to get somebody to come every day for at least 8 hours so I could sleep a little, maybe go to church, which my husband and I could not even go to church together, but for twice in a year. Never went anywhere together, but maybe to church twice a year, and maybe to one function, maybe 3 times in 8 years, every year. That's all we were able to do. Senator, this is the second time I'm here to testify in support of changing the process. This is basically a good bill for both claimants and the defendants. The claimants will be better able to afford this pre-screening process, and it gives the defendants an opportunity to settle the claim even before the judge reviews the evidences. The following are my understanding of the various subsections and a few comments. Instead of mandatory mediation, subsection 102 says any claim for damages shall be submitted to mandatory malpractice pre-screening. Subsection 103 has to be revisited because line 15 uses the word petitioner, which does not have a definition. If we assume that the word should be claimant, then this section is confusing. Subsection 104, the defendants have 20 days to respond, and if they fail to file a response, then the claimants may proceed in default to pre-screening. In the next section, 105, the word respondent was removed from the list of definitions. I think it should be defined. Subsection 101, this is where the action begins, as the lawyer mentioned, medical malpractice pre-screening. The claimants are, first of all, they're required to give the defendants a 45 notification to a health care provider. Oh, I thought, we want to sue, we're going to go to the lawyer, and the lawyer's going to file something in court. No. We've got to inform the health care provider in 45 in advance, because why? Due process, they got to go find their witnesses, they got to go research, they got to go interview all of the individuals involved. Oh my goodness, so they have and so do we. We have 45 days to notify the health care provider of the claimant's intent to file for a pre-screening. We're not even filing it, we're just intending to file it. This means 45 days to prepare testimonies, etc., plus 20 more days to respond to the claimant. They have 20 more days to respond. And B, the healthcare provider can express sympathy and all the words that goes with that subsection, and this sympathy is inadmissible as evidence of an admission of liability. How can they deny that line item? Possibly some claims can be settled before the pre-screening. These are positive points for the defendants. They can settle. And I hear from the lawyer that the argument is, if they settle, it gets in the books. Well, that's part of accountability. The more if one doctor keeps settling, then maybe he's not a good enough of a doctor. Maybe he's the doctor that needs to be kicked out of the system. As a practitioner here in Guam, that is the accountability part. How many times do people have to make a claim against him? Next in the process is C. When the pre-screening complaint is received, the case is sealed and is referred to a judge for the pre-screening. And then in D, finally, the pre-screening is conducted promptly. And as the lawyer said, I don't understand what does promptly mean. Is it unreasonable to expect a timeline, a definition, or clarification? We do need to clarify that word. The pre-screening is held in camera. I too noticed that. What do you mean? Videotaped? And the lawyer explained it, that is, I forget, but it's not a matter of just videotaping. We need to define that word. And may use technology to expedite the process of bringing witnesses together, which would cut travel and other related expenses. E then says, this is when the judge makes the decision. If the judge finds that the evidence proves the defendants are guilty, then the judge will proceed to set a monetary settlement value on the claim, distinguishing between economic and non-economic damages. Basically, this process is straightforward and cost-saving. The process satisfies the need of the claimants to claim damages, and if the defendant is found guilty, he, she, or they will be accountable. Before I close, I want to explain the confusion some of us may have had relative to the existence of the Guam Board of Medical Examiners. This board only receives complaints against doctors, but it is not the education process for medical negligence claims. At least that's what I understand. We need the passage of Bill 83-38 because the Guam Board of Medical Examiners has never ruled in favor of a patient complaint in almost 7 years. We need a legal process to file claims for damages due to medical malpractice in the most cost-effective way. Finally, but not the least, I want to thank Senator William Parkinson for filing this bill, which unfortunately did not secure any co-sponsors. Senators, I urge every one of you to once and for all pass this bill and send it to the governor's signature. It is time for our healthcare providers here in Guam to be accountable for any acts of medical malpractice. May I add a couple more comments? Because my son was bedridden for 8 years, I've gone in and out of GMH over the years. And there was one point in the very beginning, there was a misinterpretation of my information, and which cost like a week in the telemetry. And so when I wondered why they put him in there, and so I inquired, and they said that I said that he had lung problems. I go, no. So I actually wrote it down, and it was sent to their board, and it took, I think it was a minimum of 30 to 45 days. So I used the system at the hospital. They reviewed it, and they made a decision. I have a copy of their decision. Then the second time, but it was a few years later, there was absolutely one doctor who was so unprofessional. I would not allow her to take 2 feet into my son's room. She was so condescending. Everything that came out of her mouth was very condescending. So I did ask to meet with the manager, the director. I didn't get to meet with her, but the deputy. And unfortunately, I did not think of going through the board of medical examiners. You know, when you're busy taking care of somebody for 8 years, you don't really quite think. I did make a complaint, and they did do something with it. They talked to her, explained to her that she went overboard, very unprofessional behavior. So I have gone through some of the processes, but I did not quite understand at the time that there was a Guam Board of Medical Examiners. But all around, it is better just to go straight to the courts when we have a problem, because even though you have people at the hospital level who are deal with patients and their concerns, you don't really understand the totality. I think we think in terms of seeing a lawyer, checking with a lawyer. And as I mentioned earlier, that's our biggest step. My biggest step was the lawyer said, even if I won the case, there'll be so little money, because you don't know how long your child is going to be bedridden. And for me, it was 8 years. And that was, and our support system here on the island is not really satisfied. There are too many roadblocks, especially for people with a tracheostomy. You cannot pay Catholic social services people. They're not allowed. They can bathe him, but they cannot suction him. Any kind of low-level nurse, they can bathe him. They can't suction. It's very complicated, and that's why I went this route. And I didn't even get through the mediation process. No lawyer wanted to take my case. Really. Thank you for the time.
Thank you so much. Yeah, I was asked earlier, or told earlier, that it is very difficult to find attorneys to take on this case because of the hurdles and the costs associated. It's very difficult. So at this time, I would like to here to testify. Hold on. Okay. At this time, I'd like to recognize Robert Celestio for his testimony. Thank you so much.
Sejus Masi, Chairwoman Taitague, and Senators. I want to just share what Senator Gumatato said earlier. He is, what you call that? Before the doctors were here, you were intimidated because all the doctors were here. How much more the patients out there who can't come in here because they're intimidated. So my name is Nanu Robert Namalik Celestio. I'm testifying and share my story. When I came back from Washington, D.C. in 2023, I had edema on my ankles. So I went to the Naval Hospital. So they suggested I go and have a kidney biopsy. So I went over to GMC and got a biopsy. But what had happened is that I told the nurses there that I was on blood thinners from Naval Hospital. They said, oh, that's okay. So the doctor was on his way from GMH. I was put on the table. He did the procedure. And then afterwards, I complained about the pain on my back. So they transferred me back to Naval Hospital. To find out that when I got in the room, I passed out. I passed out because I had internal bleeding. And I felt sorry for my wife because they couldn't explain what I was doing in surgery for 10 hours. And when I woke up, I was at GRMC on life support. I had this thing down my throat. And when I woke up, my hands were tied on the bed, and I was gasping for air for them to take it out. And the reason my hands were tied, they explained, was so I won't pull it out myself. So then I found out I had to be on dialysis. So I asked GRMC to transfer me back to Naval Hospital, which they did. And when I got to Naval Hospital, they had 3 doctors. And they explained to me what had happened and that I had to be on dialysis. So I want to share my story because the doctors there, they had Dr. Fine. He came up to me and my wife when I was in bed and he said, you know, we had a patient just like you in Walter Reed, but he died. And I couldn't figure out why he would say that. Maybe he tried to make me feel better that I lived. And so the other doctors said, oops, we had to give you a large amount of antibiotics because we didn't know what was wrong with your kidney. And we damaged your liver. And so I was yellow, jaundice for so many months. And I had to go to dialysis Monday, Wednesday, and Friday. And they had to gurney me from my bed to from my bed to the gurney, down to the ambulance, from the ambulance to Sinahanya to have dialysis at the kidney place. This happened from Monday, Wednesday, and Friday, 4 hours a day sitting in that chair, wondering what the heck happened to me. I just went in for a biopsy, come out, almost died. Now I got to suffer for how long? And I learned a lot being in dialysis 4 hours a day, watching all these other patients in dialysis suffer also, and hear all their stories, unbelievable stories they would tell me. And I just told the Lord, I said, Lord, get me out of here. I don't want to be here. This is messed up. Excuse my French. And so what had happened is that this happened for about 4 months. I was in the hospital for 4 months. I couldn't walk. I couldn't sit up on my bed. I lost 48 pounds. And finally, they said, we're going to discharge you. But still, I had to go through dialysis. But by the grace of God, Dr. Safa said, we're going to try an experiment. We're going to take you off dialysis and see if you could recover. But the funny thing is, when I went back to Naval Hospital to do a CT scan, the technician there said, hey, we saw those 2 metal clips in your kidney. And I said, what 2 metal clips? And he says, oh, you didn't know? I said, no, I didn't know. And he says, oh, when they did the surgery, they had to close my arteries in my kidney to stop the bleeding from the one in the back. But nobody told me that. So I confronted the doctors. And I said, why wasn't I told this? And he said, oh, well, your other doctor had left off island, and then now Dr. Day would have to take care of me. And so now I have 2 clips still in there closing those 2 arteries. And so Dr. Safa took me off dialysis. And I've been off dialysis then, but find out I'm anemic. So I went back to the VA because I was in pain. He sent me to the emergency room, had a blood transfusion. I said, why do I need a blood transfusion? He said, because you're anemic. I said, I'm not anemic. He said, yes, you are now. So I had 3 blood transfusions since then. And I had to recover. I didn't want to be bedridden. I fought my way from wheelchair to a walker to the cane, and now I could basically walk. So back to this arbitration thing. I asked a few attorneys here in Guam, can you take my case? No way. I called a doctor, I called a lawyer or I emailed one in Florida. He said, no, we can't take it. I emailed one in California. He emailed me back. He said, good luck. And so I found out that it would cost about $40,000 just to go through arbitration. I don't have $40,000. So everybody gets away with whatever they do to the patients, in my case. And so I would like an amendment, a couple of amendments here. If you would take away the statute of limitations of 1 year or extend it to 5 years, because it takes a long time to go find a lawyer and a doctor and a specialist. And by the time the year is gone, and then you said, oh my God, I can't go to arbitration. And anyway, I don't have $40,000. And I took a lot of notes when I was back there. The doctor said there's a lack of fairness, but to whom? To whom is there a lack of fairness? To them or to the patients? I think if you do a round table and you get the doctors and you guys and with the patients like us, and we come up with a really good solution. They talk about lawyers getting rich. In my program, in the Radiation Exposure Compensation Act, they have a cap for attorneys that they won't take advantage of those that got the compensation. I think it's 2% cap, not sure, but I know there's a cap. So if you want to put in your amendment saying there's going to be a cap and an attorney can't just take this in frivolous lawsuits, I think that will help. It will answer their questions. And I think that cap will help a lot. And that's what happened with that program, because lawyers were coming out of the woodwork and taking the money away from those individuals who deserve the monies. And so that's why Congress had to go and put a cap on that. So 2 things. If you could put a cap on that, remove the statute of limitations, I think it will help both sides. It's going to be a win-win. I thank God I'm still alive, and I was really surprised that when I came in, there wasn't like 100 people in here. That's what I was expecting. And I was expecting a lot of other survivors. I won't call them victims, I'll call them survivors, to come and testify. But as you said, Senator Gumatauta, it's an intimidation against us. I was talking to a former senator out there, and I asked him, oh, I'm going to testify. He says, yeah, but you might not get seen by the doctors. And I said, what kind of comment is that? We're not against the doctors. It's the system. The system's the problem. The system's broken. We have very good doctors here. I wanted to tell them they got very good doctors here. They mean well. They say do no harm. Of course not. They're not going to go in there and do no harm. But accidents happen. Accidents happen, and then what happens? And I think that the pre-screening is a great idea. When I was medically retired from the Army, I had to go before a medical board. And the medical board had 2 physicians, one military, one civilian, had a military officer, had enlisted. They were the board. They made the decisions for all of us who had to go to board. And I think that would help for the pre-screening. If they're saying that it's just going to be judges or individuals, I think if you enlarge the pre-screening board, I think it will help not only doctors, but other individuals that have compassion. And I think it'll help both sides, not only the attorney, the doctors, and us survivors. So thank you and God bless.
Thank you so much for your testimony. I'd just like to recognize the mother of, sorry if I'm going to lose it here, Kaven, who's here this afternoon. If we can get AV, if you can focus in on Kaven, so those who are listening can see this beautiful baby's face. This is Kaven, who just recently passed away June 24th, 2025. Mother took him to the hospital and they released him that same day, and on the way home he died. It's very difficult right now, I know, for the family to be here today. But I appreciate you being here. It was hard for many other families who've lost children. They felt that there was medical malpractice involved in it. David Domboski and his child was here, and that was very difficult. So thank you so much for being here and sharing his beautiful picture with us and his memory. And I hope that this hearing is not going to be set aside, because there's so many of them that have passed with questions. And I don't think it's going to stop unless we do something about it, at least have people accountable for what has happened. So again, I thank you so much for being here today. Okay. If any of my colleagues would have any questions for those who are sitting, I'd like you first to offer it to, because these are the last two to testify. We will have another public hearing. We'll take a recess to 4 o'clock this evening, and we'll hear more testimony then. But at this time, I'd like to recognize any of my colleagues. Senator Gumatauta?
No, I have no questions for this panel, ma'am.
Senator Mantanan?
I also just wanted to thank this panel, Ms. Espinosa, Mr. Celestial, and especially to you, Carly, and again, my condolences for the loss of Kaven.
Thank you. Senator Terlahi?
Thank you. My condolences as well. Thank you for being here. Oh, it's very tough, especially right now. But thank you for being here and being that brave. And I know it's out of love. And I know that in many of our discussions on this type of bill, we have had many patients have to come forward in their great time of sadness and need to try to get the legislature to change a policy for others that will not help them anymore, but it might help others. So I really appreciate that. And I thank you, Ms., for your testimony again. And I'm very much, Espinosa, Ms., you've had to come here, like you said, several times, and I appreciate that. And I appreciate the way you've pointed out the real practical implications, the process from your view, how you have tried to get lawyers. And I only knew of one who was still taking cases, maybe two, and I know that one, if I remember correctly, the doctors have refused him care. And I think that has happened to senators as well. It's kind of like some of the threats that we've heard today, and I don't think that's right. But I do thank you, Mr. Celestial, for bringing up the statute of limits, because you're right. Guam is one of the very few places where there's only a 1-year statute of limits for these types of cases. Louisiana, Kentucky, Ohio, California, and Guam. And in all the other places, it's 2 years or 3 years or longer. And I agree with you. When you're trying to come up with the money for arbitration, that's difficult in and of itself. Trying to find a lawyer on Guam right now, we have a shortage of lawyers. The bar is making it critical matter for them, the Guam Bar Association, the shortage of lawyers. But to find a lawyer who actually wants to do malpractice in a community where doctors threaten not to cover you if you sue them, or even not sue them, but take them to arbitration, it's very concerning. And it's a whole big cycle we have here. And but I think that we have to really base ourselves on facts. We have to really try to do what we can. We have to realize what's going on nationwide versus is it just a Guam thing? And try to fix what we can here on Guam in every way. But I don't think that in any time that we should say it is okay for doctors to practice at a standard of care different than we require anywhere else. I don't think that we should say it's okay that on Guam it's much, much harder and much more expensive than anywhere else to bring a claim for gross negligence. I don't think that we should say our patients are any less important than patients across the nation, even though we have, as a government, gone and put our money into recruiting doctors, into covering their practice, to supporting students in every way, and we can do so much more, and we need to. But I just think some of the implications of what's being said is status quo is okay, even though status quo has proven not to be allowing claims. And even though doctors, deciding on doctors has resulted in no sanctions, at least in 3 years, maybe 7 years, like you say, Ms. Everista. I'm going to check the statistics. But honestly, we can't tell how many have gone to arbitration, even in the past when we did have lawyers, because that's all secret. It's all a secret. So we can't tell. And like you said, we can't tell which doctors are repeatedly being brought, or claims brought against them. We can't tell that right now. And so we can't tell the outcomes, and we can't tell. And so I just think it's still very difficult. Thank you for trying to get the system changes for everyone else. Yes, Ms. Evers.
I've spent so many hours on this, and I still didn't complete my testimony. And I just wanted to mention that in subsections 10, 109, and 10, there's still opportunity with mutual consent to go and do the arbitration. Yes. So what are they complaining about?
They can still go to arbitration according to the bill. They can still pay for arbitration, as they have suggested is the cure-all. They can still do that under this bill. They can still go to a different arbitration process if that's what the parties agree. They can, by agreement, almost do anything. And it's just for those who refuse to agree, then we will have, hopefully, a less costly way to screen those cases. Madam Chair.
You're very welcome, Senator Chalahi. Senator Parkinson, you have any questions?
Yeah, yes. First, I'd like to thank Mrs. Espinosa and Mr. Celestial for their testimony today. It was very illuminating, and ma'am, there was a particular part of your testimony that really touched me. I'm going to repeat it here. Sadly, I discovered on his first night home that I was not sufficiently trained, and I was immediately overwhelmed with the responsibility of keeping him alive 24/7. I lovingly took care of my son for 8 years before he passed on June 9, 2020. As a father and as a caretaker of a very sick person for a very long time, my heart goes out to you in the struggle that you had to go to for those 8 years. But what stood out to me in particular in your testimony was this. GBME has never ruled in favor of a patient complaint in almost 7 years. And I would hazard to guess, if we went back to the origin of this law, that 99% of the time, they will rule in favor of the doctors. I would be surprised if there has ever been a time that this board has ruled in favor of the patients. And so I take your point, Mr. Celestial, very, very strongly. Fair to who? None of these doctors would accept a system where 100% of the time they ruled against the doctors. So why should we accept a system where 100% of the time they rule against the patients? That is not fair. That is not fair. And that's why I introduced this legislation, because you are not going to tell me that 100% of the time this class of people never makes mistakes and it's always the patient's fault. I do not accept that. I do not accept that, and I will continue to fight for you on this bill. Whether it's in this term or the next term or the term after that, I will fight for it. I've had doctors online threatening to withhold care from me. I've had doctors in this very public hearing threaten to primary me, and I will make this vow to you. That will not stop me. I will continue to fight for you until justice is had by our patients. I will not be scared by these special interests. That is my promise to you, ma'am, and that is my promise to you, sir, and to you as well, ma'am. I will make sure you have the tools to pursue justice no matter what it takes. Even if it doesn't happen now, by God, it will happen. That is my promise. That I yield the rest of my time, Mrs. Chair.
Thank you, Senator Parkinson. As I mentioned, we're going to be taking a short recess until 4 o'clock this afternoon, which we'll come back to listen to those who were not able to make this morning's public hearing. And before I close, I just, again, Callie, my story was when after, when Senator Terlahi and I filed the first bill for medical malpractice to find some kind of way that's fair and just for the people of Guam. I was just finishing my cancer treatment. And when this bill came on the books, I had a doctor who refused to see me anymore because I was one of the co-sponsors of this legislation. But my biggest mistake was I never filed an ethics complaint about that doctor to the Board of Medical Examiners, which I should have. So there's a lot of things I should have done. And this time around, I want you to know your courage coming here today. Only just, he passed away just June 24th. Will go a long way for you being here. So I thank you for being here and invite you again to come back later on this afternoon if you can, if you're up to it. So again, thank you. And for everybody who testified, I greatly appreciate you being here this afternoon to testify. And those who did not submit your written testimony, please feel free to email that testimony to my office at senatortelot@gmail.com. We are now in recess until 4 p.m. today. Thank you. Sijus Masi.